Welcome Facebook, welcome YouTube. Here is another live video coming from Future First Criminal Law. My name is Zachary Divelbiss. I am the owner. And this video, we're going to get into it here, is going to be a little bit of our journey through the criminal justice system. This is a video that we cover pretty much every couple months, if not even more frequently than that, because of how important this is, because of how much confusion there is over the criminal justice system. Especially these days, there's so much of the process is always changing, but at our felony level, which is what I'm covering here, within Arizona, within Maricopa County, this is what we can expect. I'm sure you've seen all kinds of different graphs, flowcharts, different ways of explaining the criminal process here. It's very difficult when people ask us and they say, hey, how long is this going to take, Zach? Hey, could this be here for the next year? Could it be here for only, the next month? All kinds of different cases come out in different ways, but this video will hopefully give you a little bit of an understanding of what is happening here in our journey through the criminal justice system on the felony level. If you're facing any felonies, this is a great video for you to watch, share with some loved ones. That way you guys can all get an understanding of maybe how complicated the process is and why you need a lawyer going through it. If you're facing any misdemeanor charges, this video might not be the best for you, just in the sense that some of the names of some of these hearings might not match up the same way as they do in the felony side. But all the more important, this follows a very similar track on the misdemeanor side though. So if you're in a city court or a justice court, some of this might not be as complicated. Whereas when you're at the felony level there at Superior Court, a lot of this is going to apply, usually for your cases, although everyone kind of gets a little bit of a different process here and there. So first we start out, we got initial charges that come pretty much usually out of a citation, a warrant, something that gets you arrested. There's all kinds of different codes that this is called. Some of it's called information. We got grand jury indictments, a lot of different things here, but that's ultimately the bottom line. There's an investigation in order to start the case off, and then there has to be some formal documents to actually get the case into a court. That's what's there. If at this point you likely could be booked, or you might be released depending on the severity of the charges, depending on your criminal history. A ton of different factors go into that we won't go into in this video. Then you get your initial appearance. This is kind of what's called bail, bond. Arizona calls it different things, even though it hits both sides. Ultimately, what this means is you have a right to be heard by a judge pretty much right from the very beginning. We have a time deadline for this. There's no way that in today's day and age that they can just pretty much throw you in jail without ever letting you see a judge. So that's what this is meant for here. This is kind of the process where everything really starts. This is where all the questions happen. This is where your loved ones are likely, confused about where you are, what the process is, who can help you. This is definitely a great point to start reaching out, if you haven't already, to hire a law firm to get a lawyer on your side. At this point, charges will then get officially initiated here. Because that initial judge can also have a chance to remove some of the charges, this is where some of the charges going forward will actually stick at this point. We get into two different processes here. That's why we get a little prong, a fork in the road here of what may or may not happen. Something that is important for you to understand is we, as the defense attorneys, as the criminal justice system, we don't really control a lot of this. A lot of this is controlled by the prosecutors. You might say, whoa, Zach, that's totally, strange. I've never heard that. Why is, the judge not controlling this? Well, there are a ton of laws that go into the history, and we won't get into that in this video, but ultimately the prosecutors have a good way of controlling where the case goes at this point. What is most common, depending on the severity of your charges, depending if you've ever been through the criminal justice system, is to get over here on this right side here, where we'll waive the grand jury process, so there won't be, an impaneled grand jury to indict you on the charges. You'll be brought with what's called a criminal information or a complaint, and this is basically what we categorize as fast track. This is where we say, hey, as the prosecutor, we're going to put a case right here in this smaller style of a court because we think that this person might take a plea deal And we want to give them the opportunity to take that plea deal without having to go and set up, trial court dates, getting the bigger level judges involved. And so this is what was created there. Ton of different videos, different things that we can get into about what actually happens here and maybe some of the history of it. But what essentially, as I mentioned here, you will still go to court. You will still negotiate a case. So you might negotiate a better plea deal. Things could obviously always get worse at this court level. One of the things you might understand here is since it is the fast track process, you might not get all the evidence that you want to get, such as 911 phone calls, such as the body camera footage, maybe there's dash cam. You might know that it's out there, but you won't actually be able to get access. It won't be disclosed from the prosecutor at this stage. Either way, there are two options here. More than a few options, but one of the main one is to accept a plea agreement. If you do accept the plea agreement here at this process, and it's a stipulated plea agreement, meaning you have agreed to pretty much every detail of what your sentence is going to be, then great, they move on to sentencing. You lose your appellate rights after 90 days, after the post-conviction right passes. Or if there is open terms, such as a range of jail you might be facing there for prison. Let's say that it can be decided between 1 year and 5 years, and the judge will ultimately decide the true number. Well, you want to have your sentencing, and you're going to have a sentencing even with a stipulated plea. But at this point, whether it's a public defender, your private lawyer, what we do is we go in, we write recommendations to try and convince that judge to go as low as possible. It's a very formal process. A lot of T's are crossed and I's are dotted here at these sentencings. Of course, you still get the same post-conviction rights there in order to appeal. Very quick process, quick turnaround there. So if something goes wrong, you really have to get on it right away. Okay, that's kind of the quick and dirty process. That's how some people get through the felony criminal justice system in the matter of a month, maybe 2 months. Like I said, fast track process. Not a lot of people want to go through this process. And so how they get out of it is we move over here to the left side. Once again, it doesn't have to go and start over here. Same thing. You can go there with the grand jury process. You could be arrested. There could be warrants, citations. But ultimately, we're looking for the indictment there. Okay. This indictment's the big ticket item. There has to be a formal indictment for you to essentially get your trial rights. And what happens here is they can go through the grand jury indictment process, which is what most of the time happens. The grand jury indictments, in my opinion, easier to get approved than through the other formal hearing process, which is your right to a preliminary hearing. So this is where the preliminary hearing will also happen. That's where this middle box is going to come in play, where you say, Zach, I don't want to accept the plea deal over here. I'd like to have a preliminary hearing, which is your right to a probable cause determination. Very fancy word. Basically, in order to bring a police officer to court in front of the judge, and that police officer gets to say, this is the person that we saw, this is the description we had, this is the charges that we believe there were probable cause for, and that's pretty much it. That's what the judge gets to base the standard on of whether the case can move on to the next steps. Very, very difficult standard for you to win your case at as a defendant. Because the bar is so low there, the case is so early on. But you ultimately have that right to a preliminary hearing, which basically means there must be probable cause to support the case moving forward. Anyways, it moves through there. If you are found that there is probable cause by that judge, we'll move to the arraignment. This arraignment right here is one of the most common court hearings that there will ever be. This is what's kind of confusing for a lot of people is some people will get their summons and they're right off the bat going to get an arraignment. They're going to skip this box and these boxes over here. Like I said, it's the prosecutors who control this process, this part of the process. So a lot of people are confused. Well, Zach, why don't I get this benefit over here? Why don't I get this one over here? And they go right to an arraignment. It's part of the standard process. Basically, sometimes that usually means there's a bigger case against you. Sometimes it means it may or may not be some of your first times in the court, so they want a whole process as opposed to somebody who's been in the court process a ton of times before, where they know that maybe they don't want a trial, or the prosecutor believes they have a ton of evidence, so they maybe want to get you in and out of the system pretty quick here. Well, this arraignment process basically begins the whole long criminal process for any felon facing felony charges. This next process here, even though it's a small tab, is what's called the pretrial process. Everything, and I mean everything about the court process, is designed to eventually move your case into a trial. So everything before that's called our pretrial conferences. So it's not listed as individual court cases or court dates here. We listed as three different big prongs. There may be multiple court dates in order to solve some of these problems in the pretrial stage. So this is where, as the defense, as the prosecutor, we have to file certain motions in your defense, also to make sure that you're released to the proper place, that you're allowed to go home, in contact with people you should be or shouldn't be. All kinds of different things happen at this very early stage of the case. What we have listed here is the motions to suppress evidence. We can address the bail bond issue if you're not allowed out of jail. We can talk about ways that we can get evidence or not get evidence. And then discovery is that part of the police report, body camera footage. That's where we're going to start to get all of that here at the beginning stages of the formal pretrial process. Of course, as the case moves along, we get more evidence. We look through the police reports. We talk to your lawyers. We will always, in 99% of the time, be given a plea agreement. Plea agreements are a whole different video going into all the different things involved with the plea agreement. Suffice it to say, a plea agreement and negotiation is a big part of your case, whether you want to take a plea deal or not. As your defense attorney, we ethically have to evaluate plea agreements as potentially the best option or best resolution for you. You will have that final decision right here, whether you want to agree with the plea agreement and accept it, or whether you want to reject it and move into the trial phase further. Just as I mentioned before over here, if you do accept a plea agreement, there will be the sentencing phase. If something goes wrong at sentencing, there's a small appellate review, which means you can go back and undo what you've done before. Very rare that that happens. Especially if you have a good lawyer, that shouldn't be happening, especially if the prosecutor knows what they're doing, especially the judge. They will make sure that nothing goes wrong, nothing illegal happens in your plea agreement. Believe it or not, it is possible for it to happen, so that's why you get 90 days to appeal if there is something that was wrong or invalid in your plea agreement process. Now, if you don't accept a plea agreement, which, as I remind you, is completely your decision to do. Defense attorneys, we cannot force you to accept a plea agreement. We also, on the counter end of that, we can't force the prosecutors to always give a better plea agreement. So a lot more in the plea offer videos, not designed for this one. But suffice it to say, if you do not accept a plea agreement, your case will go to trial. It's really as plain and simple as that. Every case, every charge must eventually get to trial. There are time limitations for this to happen, and that is something that a lot of people don't realize. They don't know why that happens. This is where the process sometimes could take a couple months for someone, and then pretty much almost up to a year for someone else, depending on how long, how big the case is, how much evidence, how many witnesses that are going to be happening at this trial. The trial is a really small box here, which is not indicative of how long trials are. Trials at this felony level are for sure going to last at least a couple days, and you're more realistically looking at more like a 5 to 10 days for any standard felony trial. So a lot of time, a lot of effort goes into this. If you're thinking about going to a trial, strongly recommend hiring private counsel, a private defense attorney, in order to represent you at this. Due to the nature of how serious it is, how long it's going to take, the amount of sole dedication you want to your case. Of course, you will then get a jury. The jury will then pretty much have two options, whether to find you guilty or not guilty. If you are found not guilty, then great. Go for an expungement after that, and life goes on. You basically get released from all punishment at that point if you're found not guilty by the jury on all charges. And then you continue on. The prosecutor can try and appeal it if there was something that happened wrong, which may start the case over again. Not what you want, but that's a legal option for the prosecutors. Guilty, on the other hand, is a more common verdict that happens here in Maricopa County. Well, we have some tough jurors here in our community, but nevertheless, a guilty verdict is something that is a very real possibility for you if you're facing criminal charges and if you go and have a trial. If you're found guilty, it's a unanimous decision by all of the jurors, which means everyone must agree. Then they move on to the sentencing phase. The sentencing phase, however, is similar to these over here, where this is the judge who gets to decide any of the punishment. Keep in mind, there's no plea agreement at this point, so the judge has ranges that the judge can look at. Once again, the defense attorney representing you is going to argue for the lowest. The prosecutor is going to probably go for the highest. The judge gets to decide at that point. Rest assured, though, that's better than the jury deciding for you. Sometimes these juries don't really know, and they're not allowed to know what punishments are, what's standard, what's normal for some of these cases. We've had juries who say they want people to, be in jail for the rest of their lives for what's seemingly a relatively minor incident. And then some, on the other hand, who would want less jail than a judge. So it's a big curveball, ultimately taken out of the hands of the jury because it's going to go to the judge for sentencing. Same thing if there's errors, you have appellate rights. As part of this, it can continue to go on further than the 90 days as previously discussed there. So this was a quick overview of the criminal justice process specifically for felonies here in Maricopa County. There's a lot more that goes into this, but once again, this video is something that we make every month or two in order to get this content out there to you in case you, a loved one, are watching and you're confused about the process and why does this take so long and what are the maps that you guys are showing us, these flow charts. They're different ways, and not to minimize how serious the nature of these charges are, but it's essentially like a game in some sense where between the prosecutor and your defense attorney, we're trying to navigate where on the board we're playing and what's the best route for you. Very often there's only so much we can do to change the board and change the game other than trying to get a case dismissed. But understand there's a process for this because your case isn't unique in the sense that it's never happened before. Maricopa County processes a ton of criminal cases every single day, so there has to be a process of flow in order for these judges, in order for the system to work. So if you have any questions, if you or a loved one are going through the felony criminal process or have any questions about the criminal process, please reach out. Find us on our website, futurefirst.law, and we're more than happy to help you answer any of those questions you may have.